Welcome to the Deep Dive. We're here to unpack complex issues, often legal ones, and turn all that dense info into insights that hopefully help you stay well informed.
Exactly.
Think about like a high-stakes chess game, but playing out in the legal system, where every single move, especially by a top court, can just instantly ripple outwards.
Yeah, with real-world consequences.
Huge consequences,
Yeah.
affecting potentially millions. And today, we are plunging headfirst into a really fascinating and honestly incredibly fast-moving story.
It really is moving quickly.
There's this recent Supreme Court ruling just handed down this morning, Friday, June 28, 2025. And the fallout, it's immediate, it's dramatic, and it concerns something really fundamental in American law: birthright citizenship.
The cornerstone, really.
Totally. So we're going to be digging into the transcript from a legal analysis show, a segment by Michael Palpak, to get right to the heart of what went down. The big questions for us are, what exactly did the Supreme Court decide that sent these, shockwaves? And how did legal advocates, this part is amazing, respond within minutes? The source calls it a monumental shift in strategy. It's like 3D chess with the Supreme Court.
It really is. And our goal here, with this deep dive, is to understand not just what happened in this legal whirlwind, but why it matters so much.
Right.
And crucially, how this new legal landscape is going to affect something as basic as birthright citizenship. We'll be dissecting the strategies, the implications, the very real human stakes, all through the lens of this specific analysis we're looking at.
Got it.
And just to reiterate our usual commitment here, the source material, this legal commentary, it definitely has its own perspective. It uses some strong language.
Okay.
But our job isn't to endorse that viewpoint. It's just to convey the ideas in the source, give you, the listener, a clear, comprehensive, and impartial look at the legal arguments and the reactions as they were presented. We want you to grasp the complexities,
Absolutely. Okay, let's unpack this. The commentary jumps right into the breaking news from this morning, Friday, June 28th. A Supreme Court ruling that, well, it undeniably sent shockwaves. If we strip away the legal jargon, what's the absolute core of this decision? What did they actually do?
Okay, so at its heart, this decision is about limiting judicial power, specifically the power of lower federal judges.
Okay.
The court ruled that a single federal judge can no longer issue what's called a nationwide injunction or a universal injunction. Basically, they can't block an executive action across the entire country all by themselves.
So if the president issues an order, one judge can't just stop it everywhere.
Exactly. Not anymore, not unilaterally. And the source really emphasizes this point. This overturns, quote, 100 years of precedent. That's huge.
Wow, a century.
Yeah. For 100 years, district courts have used this power to stop potentially harmful actions on a broad scale quickly. And now that specific tool is, well, severely restricted.
And the timing relates to birthright citizenship.
Well, the immediate context, as the source explains it, is a potential executive order from Donald Trump. The commentary describes this potential order as aiming to challenge birthright citizenship.
Okay, so the ruling isn't about birthright citizenship directly, but it's connected.
Precisely. The timing and the implications are deeply tangled up with that very sensitive issue. And what's fascinating is how the source frames this. It's a significant centralization of power. Meaning it effectively reserves the big power, declaring a policy or an executive order unconstitutional nationwide for the Supreme Court itself. It pulls that authority away from the lower federal courts.
That seems like a massive shift in how checks and balances work at that level.
It really is. Think about the strategy. Before, one judge could act as a quick, broad check. Now, to stop something nationwide, cases might have to crawl their way up, maybe circuit by circuit, to the Supreme Court.
Which could lead to confusion.
Yeah.
Like an order is blocked in California, but active in Texas.
Exactly. A patchwork of injunctions, huge confusion, different outcomes for people depending on where they live. It fundamentally changes the balance between the White House and the lower courts.
Okay, that is a seismic shift. So the Supreme Court takes on more power here. Does that mean every big executive action fight just lands on their doorstep now?
Yeah.
Or are they going to be swamped?
That's a really good question. On one hand, maybe. Centralizing this power could increase their workload for certain cases, but then you have these signals, these Easter eggs, as the source calls them.
Right, the hints for the justices themselves. That's where it gets really interesting.
Right.
What did Kavanaugh and Sotomayor actually say?
Okay, so this is key. It suggests maybe a different strategy or perhaps an internal conversation within the court. Justice Kavanaugh, he wrote a concurrence. That means he agreed with the final decision but had his own reasons.
Okay.
And in that concurrence, he suggested that class action lawsuits could achieve a, quote, functional equivalent of a universal injunction.
Functional equivalent, meaning get the same result just through a different legal process.
Pretty much. He's hinting that while a judge can't issue that nationwide block on their own, a group of people with similar claims, acting together in one lawsuit, a class action could still get that kind of broad relief. It's a different door, basically.
Interesting. And Sotomayor, she dissented, right? Disagreed with the ruling.
She did, and she was even more explicit. In her dissent, she straight up, quote, advised plaintiffs to file class action suits and seek temporary injunctive relief for the putative class pending class certification.
Whoa, okay, break that down. Putative class. Temporary relief.
Right, so putative class just means the group proposed to be the class even before the judge officially says, yes, this is a class action. And the temporary relief, like a temporary restraining order, would protect that group right away while the court figures out the whole class action certification thing.
And the source says that's exactly what the lawyers did.
Exactly to a T, as the source puts it. Almost like they were just waiting for the signal. It shows this incredible level of, well, communication or maybe just very accurate prediction between the court and the lawyers on the ground.
They even poked fun at Kavanaugh.
Yeah, the source mentions the lawyers in their filing did a little roasting of Kavanaugh by quoting his own concurrence back at him to support their class action move. Which is legally smart, right? Using the court's own logic.
Definitely a power move. But why? Why would justices basically hand over a playbook on how to get around the main point of their ruling? Seems counterintuitive.
It does raise questions, doesn't it? Maybe it's complex internal dynamics. Maybe they want to limit individual judicial power but still see a need for broad relief in certain cases, especially constitutional ones.
So channel it through a more complex process like class actions.
Perhaps. It could be a way to manage their own docket, too. Make these big challenges go through the procedural hoops of class certification in the lower courts first. Or maybe it's just a fundamental disagreement within the court about how best to provide remedies for big systemic issues, like saying, okay, this specific tool, the nationwide injunction by one judge, is restricted, but this other tool, the class action, is still available for broad relief.
It's like anticipating the chess move and having the counter move planned before the first piece even hits the board.
Exactly.
And that speed. That's what's so striking. The commentary says within 90 minutes. 90. Lawyers were already filing. What did they file exactly? And how on earth were they so ready?
The speed is just astounding. It really tells you about the preparation involved. Within, 90 minutes of the ruling coming down, lawyers in Maryland, specifically before a Judge Boardman, filed a motion for class certification and a temporary restraining order, or TRO.
And these weren't just slapped together.
Oh no, the source is very clear. These papers were already prepared. They had anticipated this exact outcome from the Supreme Court. They were ready to act, especially considering Justice Sotomayor's dissent.
So they had drafts ready, based on different possible outcomes.
It certainly seems that way. The source mentions discussions with legal experts like Leah Lippman, where it was almost a joke, oh, the papers are probably already drafted, and then boom, an hour later they're filed. It shows that intense proactive work.
And why Maryland? Why Judge Boardman?
Good question. The source reminds us that the Supreme Court's decision that morning actually involved 3 specific cases where lower courts had issued nationwide injunctions previously. One was from Rhode Island, one from Washington State, and one was from Maryland.
Ah, so Judge Boardman might have already been familiar with the underlying issues.
Possibly, and those prior nationwide injunctions from those 3 states. The Supreme Court ruling meant they have been pared back. Their nationwide scope was gone. So the lawyers went back to one of those specific courts, Maryland, to try the new strategy, the class action.
Okay, and the TRO, the temporary restraining order, what's the goal there? Just hit pause.
Essentially, yes. Hit pause. It seeks to pause enforcement of any potential executive order challenging birthright citizenship until the courts can rule properly on the case. It's all about preventing, quote, irreparable harm.
Irreparable harm, like what we'll discuss later, the impact on actual people.
Exactly. Preventing that harm before it happens, while the legal gears turn. Now, from the perspective of, say, the Trump administration, As the source anticipates they'd oppose this, they'd likely see this TRO and class action filing as an attempt to block a legitimate executive action aimed at, securing borders or defining citizenship according to their interpretation.
Right. They'd see it as obstructing policy.
They'd likely argue it's a procedural tactic to frustrate executive power, especially after the Supreme Court just tried to limit judicial overreach with nationwide injunctions.
So this rapid response really shows how sophisticated these legal groups are.
Absolutely. They're not just reacting, they're anticipating, planning, drafting for multiple scenarios. They took what looked like a loss from the Supreme Court and, using the justice's own signals, immediately turned it into a new legal fight. It's high-level strategic lawyering.
Okay, so the Supreme Court nudged them towards class actions. This is the new battlefield. But when most of us hear class action, we think, faulty airbags or maybe some kind of financial fraud case. How does that concept even apply here to something as fundamental as citizenship? Give us the legal AF TED Talk on class actions in this situation.
Right. It's not the typical consumer class action image, is it? But the legal tool they're using here is actually tailor-made for this kind of situation under the new rules of the game anyway. They're using a specific part of the rule book, Rule 23B of the Federal Rules of Civil Procedure.
Rule 23D2. Got it. What does it do?
It's designed precisely for situations where one party here, the government, hypothetically acting through an executive order, is accused of acting or refusing to act in a way that affects a whole class of people generally. And because the action affects everyone in the class similarly, the rule says that injunctive relief, stopping the action, or declaratory relief, declaring the action illegal, is appropriate for the class as a whole. The main goal isn't money for individuals, it's changing the policy or stopping the harmful action for everyone in the group.
So the class here would be?
The examples given in the source are parents of children affected by the Citizenship order. You can see how that fits, right? It's potentially a very large group that's numerosity in legal terms. And their core claim that the order unconstitutionally affects their child's citizenship status is typical across the group. That's typicality.
So instead of thousands of individual lawsuits.
Exactly. One judge handles the core constitutional questions in one courtroom, with a few representative plaintiffs speaking for the whole class. If the judge agrees the class is proper, certifies the class, and finds the executive order unconstitutional, any relief granted, like an injunction stopping the order, applies to everyone in that certified class.
That sounds efficient, but also powerful.
Very. And the source gives an example. A previous case with a Judge Boasberg. He apparently certified a class of 250 people. These were individuals reportedly sent to El Salvador in the middle of the night without due process or habeas corpus rights.
Wow. Habeas corpus, the right to challenge unlawful detention, right?
That's the one. A fundamental right. And Judge Boasberg issued a class-wide injunction protecting all 250 of them. And here's the kicker, connecting back to Kavanaugh.
The functional equivalent.
Exactly. As Kavanaugh's concurrence noted, a class-wide injunction, especially for a large and spread out class, can be the functional equivalent of a nationwide injunction.
So the Supreme Court closes the front door on nationwide injunctions from single judges.
That leaves a back door open, yeah. A more complex, procedurally demanding back door, maybe, but still open. The class action lets advocates build that broad group, and if they succeed, get a remedy that acts like a nationwide block, even if it's technically just for the certified class.
And the administration's counter-argument would be?
They'd fight the class certification itself, argue the group isn't numerous enough, or the claims aren't typical, or individual situations are too different. They'd try to prevent that functional equivalent from ever forming, arguing it's an end run around the Supreme Court's ruling.
It really shows the strategic pivot, doesn't it? Adapting instantly.
It really does. A tactical shift from trying to get one judge to issue a nationwide block to building a collective case for a class-wide block. The legal system adapts.
Okay, it's clear this isn't just abstract legal theory. The commentary keeps hitting this note of human cost and irreparable harm. Let's get practical. What are the real day-to-day impacts for the people caught in the middle here, especially newborns, if an order like this went into effect and wasn't stopped?
This is where it gets incredibly real and frankly quite scary for the families involved. The urgency behind that TRO filing comes directly from the immediate threat to babies born right now on U.S. soil who could suddenly be deemed non-citizens, potentially, depending on how such an order was written and implemented. Imagine your new parents. Your baby is born here. You go to get a passport, maybe for a family trip, and you're denied. Suddenly, your child's identity, their future, is thrown into chaos.
What kind of consequences are we talking about beyond passports?
Oh, fundamental things. The source mentions loss of federal benefits citizens are entitled to. Think access to healthcare programs, getting a social security number, which you need for almost everything eventually, access to public education down the road.
They'd be in a legal limbo.
A profound limbo. The source uses the term nationless people, and it asks that really stark question. They're born here. What country are they a part of? Who's going to issue them a passport?
That's chilling.
It is. And it's not hypothetical. The source gives that specific example, a baby needing a passport within the first 3 months for travel. It highlights how immediate this becomes. Think about registering for daycare, doctor's visits, just establishing a legal identity. All of it becomes a complex, uncertain legal battle.
And the source mentioned something about red states.
Yeah, it specifically flags babies born in red states, like right now, as potentially being immediately cut off from benefits if an order took effect without a broad injunction. It suggests that without that uniform protection, you could see inconsistent enforcement, maybe politically motivated, making the situation even more precarious depending on where a child happens to be born.
So this isn't some future problem, it's immediate.
It's presented as an immediate present danger. The potential for life-altering, irreparable harm is the core reason for seeking that emergency TRO. It's about preventing this damage before the bigger constitutional questions get fully resolved, which could take a long time.
Which underscores why the speed of those legal groups was so critical. The source gave them a tip of the hat, right? Who were they again?
Yes, a well-deserved tip of the hat. The commentary specifically names two: the Asylum Seeker Advocacy Project, ASAP, and the Institute for Constitutional Advocacy and Protection at Georgetown University Law Center, often called ISAPI.
And they're praised because they had everything ready.
Exactly. They had the motions ready to go, not drafted frantically afterwards, but meticulously prepared in advance, anticipating this very scenario. That's what allowed them to file within that incredible 90-minute window.
Shows real foresight.
Incredible foresight, coordination, deep expertise. These aren't general practice lawyers. They are specialists deeply immersed in constitutional and immigration law. Their swift action ensured the legal challenge was immediate, preventing a potential period where people were left completely unprotected and signaling that the fight would continue just on this new class action terrain.
Okay, so they've made the first move in this high-stakes chess game. They filed for class certification and the TRO. What happens right now in Judge Boardman's court? What's the sequence of events?
Okay, so the immediate focus is on Judge Boardman in Maryland. First, she has to deal with that request for the temporary restraining order, the TRO. That needs a very quick decision because it's about preventing immediate harm. The source even suggests we might hear something as soon as the next day.
Wow, that fast.
That's the goal with TRO's speed. At the same time, she has to tackle the class certification request. This involves getting legal arguments or briefing from both sides, the plaintiffs and the government, likely on a very short track, meaning fast deadlines. Then she'll hold oral argument, where the lawyers make their case directly to her.
And the source mentioned she might have already formed an opinion on the executive order itself.
It notes she has already said that executive order is unconstitutional, likely based on previous related cases or arguments she's heard. But the Supreme Court's ruling changes the game. Now, her focus isn't just on whether the order is constitutional, but on the remedy. Can she use this class action mechanism, Rule 23b-2, to grant relief now that the nationwide injunction option is off the table for her?
And the administration will fight this hard.
Oh, absolutely. The source expects strong opposition. They'll fight the TRO, fight the class certification, argue the order is legal, argue the class action isn't appropriate, argue it undermines the Supreme Court's ruling. It'll be a fierce battle right there in her courtroom.
Okay, so let's say Judge Boardman rules. Maybe grants the TRO, maybe certifies the class. What's next? Appeal.
Appeal, almost certainly by the losing party, and the source anticipates the administration would likely be the one appealing Judge Boardman's decision if she rules against them. That appeal goes to the Fourth Circuit Court of Appeals, which covers Maryland.
And what's the vibe at the Fourth Circuit, according to this source?
The source describes it as having amazing judges, most of them moderate. This suggests the plaintiffs might find a potentially receptive audience there, but of course, appeals are unpredictable.
And this is where the core issue comes back. Birthright citizenship itself.
Exactly. This is a critical shift. The Supreme Court's ruling was procedural about how you can get an injunction. The Fourth Circuit appeal, however, will likely dive deep into the merits. The fundamental question: Can Donald Trump, by executive order, rip out the beating heart of birthright citizenship?
Based on the 14th Amendment.
Precisely. That post-Civil War amendment stating, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens. That language, especially subject to the jurisdiction, has been interpreted for over 100 years to mean birthright citizenship applies broadly.
So the administration would challenge that interpretation.
That would likely be their argument, yeah. Maybe arguing children of undocumented immigrants aren't truly subject to the jurisdiction in the intended sense, or that the president has the power to interpret or clarify that via executive order. The Fourth Circuit would have to grapple with that huge constitutional question, the one the Supreme Court sidestepped in its procedural ruling.
And after the Fourth Circuit rules.
Then, the loser there takes it to the final level, on an emergency application to the United States Supreme Court over the summer.
Emergency application, does that mean super fast?
Sometimes, but the source is skeptical here. It thinks a quick decision based just on written briefs is unlikely given the magnitude of the issue. Instead, it predicts the Supreme Court would want additional briefing and full oral arguments.
Which takes longer.
Much longer. It could easily push the case into the next Supreme Court term, which starts the first Monday in October. So while that initial 90-minute response was lightning fast,
The whole process could drag on for months, maybe longer.
easily, leaving people in limbo, amplifying that irreparable harm concern. It really is a high-stakes game with huge consequences hanging on every step, and time itself becomes a critical factor.
So let's try to pull this together. What does this all mean? We've seen a Supreme Court decision that, well, it fundamentally reshapes judicial power, taking away a tool lower courts used for a century.
A big shift, yeah.
Then this incredibly fast, almost pre-planned strategic reaction from lawyers, using hints from the justices themselves to open up a new path. This more complex class action route for fighting for fundamental rights like birthright citizenship. It really shows how dynamic the legal system is, doesn't it? Even when new hurdles appear.
It absolutely does. This whole scenario, as the source lays it out, just perfectly illustrates that constant push and pull between the branches of government. And it highlights how critical legal strategy is in shaping policy, maybe now more than ever.
It's a reminder that even when one legal door seems to close,
Advocates will immediately start looking for another window, another path, even if it's harder to navigate. This dance between court rulings and legal responses is what keeps the system evolving, even if it adds complexity. The fight over constitutional meaning just moves to a different arena.
So as we wrap up this deep dive, here's something to think about. The source emphasizes the Supreme Court's recent decision wasn't really about the substance of birthright citizenship itself. It was about procedure, who gets to block a presidential action and how.
Right, the merits were set aside for now.
Okay, so given this long, complex road ahead through class actions, appeals, potentially stretching into the next Supreme Court term, what does this new procedural reality mean for the certainty of fundamental constitutional rights in America? If the process to protect them becomes slower, more complicated, does that affect the right itself?
That's a deep question.
And maybe related, how might this shift impact public trust? Trust in the speed, the accessibility of legal remedies, especially when those remedies involve something as basic as a person's citizenship status from birth.
Lots to consider there.
It really is. Definitely something to mull over. We certainly encourage you to keep an eye on this story as it continues to unfold. The implications are huge and will be playing out in courtrooms for some time to come.